5 seconds to go. Start. Expenditure of rupees 2,69,355, which is to be contrasted with the income of rupees 3,01,561 during the check period. Stop. These facts clearly demonstrate that there is no prima facie case made out by the prosecution, and therefore the appellant was entitled to be discharged. Stop. Para. The conclusions that we have drawn are based on materials placed before us, which are part of the case record. Stop. This is the same record that was available with the special judge vigilance when the application under section 227 of the CRPC was taken up. Stop. Despite that, the special judge vigilance dismissed the discharge application on the simple ground that a roving inquiry is not permitted at the stage of discharge. Stop. What we have undertaken is not a roving inquiry, but a simple and necessary inquiry for a proper adjudication of an application for discharge. Stop. The special judge vigilance was bound to conduct a similar inquiry for coming to a conclusion that a prima facie case is made out for the appellant to stand trial. Stop. Unfortunately, the High Court committed the same mistake as that of the special judge vigilance. Stop. Para. Apart from the above analysis, we would note that great distress that the allegation relating to appellant's disproportionate income in the period between 1974 and 1988 was levelled in an FIR filed 12 years after the said period concluded. Stop. The charge sheet came to be filed 7 years after the registration of the FIR. Stop. The application for discharge came to be dismissed on 28th March 2016, almost after a decade of filing of the charge sheet. Stop. The dismissal was affirmed by the High Court 7 months thereafter, that is, on 5th October 2016. Stop. Finally, and most unfortunately, the present SLP has been pending before this court for the last 6 years. Stop. In the meanwhile, the appellant superannuated from service in 2010, but had no option except to contest the case. Stop. He is now 72 years. Stop. Continuation of the prosecution, apart from the illegality as indicated herein above, would also be unjust. Stop. Para. For the reasons stated above, we allow the criminal appeal arising out of SLP criminal number 9601 of 2016, and set aside the judgment and order of the High Court of Patna in CRLM number 23031 of 2016 dated 5th October 2016, and that of the Court of Special Judge Vigilance, Patna in special case number 09 of 2000, dated 28th March 2016, and discharge the appellant. Stop. Para. No order as to cause. Stop. Para. Leave granted. Stop. Para. This appeal is against the concurrent dismissals by the trial and the High Court of the application for discharge filed by the appellant under section 227 of the Code of Criminal Procedure, 1973. Stop.